Madilim. We okay, Jonas?
Nandiyan na si Director Vistan, labo mata ko. Magandang hapon, Director Vistan. Kita madilim ba o wala pa siya?
Good afternoon, Commissioner.
Good to see you. Professor.
Binshel, good afternoon.
So, good afternoon. Basta na.
Okay naman po.
Hi, Mark.
Nasa magna-90 na yung attendees natin, sir. Nakikita ko dito sa participants.
Okay.
Ano sila? All UP law students? O iba-ibang?
Most of them are, sir. Siguro may ilan pong mga supervising lawyer. May nagte-text. May nagme-message nga sa akin kanina asking if they have started the meeting kasi naghihintay na yata siya na isang supervising lawyer.
Kung pwede na siguro, I see 102 participants already.
All right. So, would you do the Would you do the
Yes.
introduction?
Yes, come. All right. Good afternoon. I am Raquel Ruiz de Malanta, and it's my honor to be your moderator. For this afternoon, we have a 2-hour webinar from 4 to 6 p.m. on the expanded Electronic Lawyering Service, or EELS, of the Commission on Human Rights. It is a public service program where the Commission accepts and responds to queries for legal counseling from the general public on everyday matters involving human rights issues. An initial electronic lawyering service, or ELS, was initiated by the Commission in March of this year, which was born from the unprecedented health crisis brought about by COVID and the multifaceted restrictions and human rights issues that came about as a result. Now we are expanding the reach of this service, thus the expanded ELS or the EELS. And the two commissioners who have conceived this program are Commissioner Roberto Eugenio Cadiz and Commissioner Gwendolyn Pimentel Gana. Who's Gwen? Ma'am? Yes, Commissioner Gwen. This afternoon's activity is the first of a series of webinars that the Commission is undertaking with its partners. So our participants today come mostly from the UP College of Law, Office of Legal Aid. And they have committed their support for this project thanks to the auspices of the UP College of Law Dean Fides Cordero Tan. Thank you, ma'am. And OLA Director, Professor Carlo Vistan, who join us this afternoon. Welcome, Dean Cordero Tan and Prof. Vistan. Before we proceed, please be advised of our house rules. The participants will be muted during the presentation of the speakers, but please feel free to post your questions using the Q&A feature of the platform. Kindly make sure that you use the Q&A feature rather than the chat function so that we can take notice of your questions. We will collate all of these and try to address as many as we can during the open forum, which is scheduled after all speakers have made their presentations. Due to time constraints, we may not be able to address all questions, but rest assured that we will save them and send the answers to you, especially if it pertains to the operational protocol for EELS. Please also note that we will be recording the proceedings for posterity as we will upload this to the Commission's website to serve as part of a training and knowledge base to support the EELS. Hence, we will consider your continued participation as your implied consent to this recordation. For our OLA interns, kindly note too that we will request you to type in your names at certain parts of the program for record purposes. Can you please do that now? Dear students, can you kindly type in your names in the chat box? Now, to welcome you and to tell us a little bit more about the EELS, may I turn over the floor to Commissioner Roberto Eugenio Cadiz.
Thank you very much, Attorney Raquel. Good afternoon to all of us. Magandang hapon po, Dean Cordero Tan. Magandang hapon, Director Vistan. Magandang hapon, Dean Diokno. Magandang hapon sa ating mga ibang profesor sa UP College of Law at sa ating mga colleagues sa legal profession. Magandang hapon sa mga kawani ng CHR. Si Com Gwen just called me an hour ago to say that he got caught in another activity. She was supposed to participate and deliver the closing remarks. Unfortunately, she's not here, but she will be watching the tape of this. So magandang hapon na rin sa iyo, Gwen. Kakantsawan sana kita na ikaw ang ating tulay kay Presidente Duterte at sa kanyang mga kaibigan sa pagbibigay ng lunas sa ating mga problema. Pasensya ka na, hindi ko maiwasan na banggitin ito. But you are my favorite Pimentel in the Commission on Human Rights. Anyway, isa lang naman yon. Anyway, at magandang hapon lalong-lalo na sa ating mga malapit ng maging abogado sa UP College of Law. So magandang hapon. We've been looking forward to this seminar this afternoon for a long time. We've been planning for it well because it marks the beginning of a promising collaborative relationship between our two institutions. The first time that we are doing this as a National Human Rights Institution, that we are formally partnering with an academic institution, which in this case is the UP College of Law, but we do intend to expand our network to other colleges of law as well, and hopefully with the College of Law of our esteemed Dean Diokno. So this is the first time, as I said, that we are partnering and we are engaging the technology, the smart cell phone technology and other platforms in rendering quick legal advice to our poor citizens on the streets, those who encounter threats of or actual human rights violations daily. And as you all know, right now, our commission is swamped with requests for assistance. And there are certain times when we just simply, there are lean days, but there are times when we really need to reach out to other sectors, such as the UP College of Law. The concept of this is rendering advice to preempt violations, because in our experience, quick legal advice would normally cut a potential or stop potential violations, and then the society is all the better for it. Hindi na umaabot sa korte. So this is the concept, and the technology is there, and we want to avail of that. And let me just say that at the get-go, there were no barriers raised by Professor Vistan and Dean Tan regarding this collaboration proposal from our institution. In fact, I was actually expecting na rin. Pleasantly surprised at the same time that in my first meeting with Professor Vistan, his question was, what do you want to happen in this program of yours, and what do you expect from us? There were no complications, there were no formalities, he was immediately trying to see as to how we can affect this collaboration in upholding human rights, and how the UP College of Law and the program that he heads could be mobilized in this effort. So, well, to our students, as you all know, we are taught in freshman, well, especially under the Bill of Rights, the rights that all citizens are entitled to. We the very first thing that this told us is that life, liberty, and property cannot be deprived of us without due process of law. There are also many freedoms that are guaranteed Let me enumerate some of them: the freedom of speech, freedom of expression, freedom of the press, and then our right to assemble, to collectively fight for these rights, and also our right to form unions and associations, to be more effective in claiming these rights. And these things are basic for us, are basic to all of us. But the concept of human rights is actually quite expensive. If you look at our laws, they're pervasive. If almost all our laws are underscored by principles and the international human rights law. But the problem is in the implementation. They might be in black and white, but oftentimes in the implementation, many abuses and violations are committed by government. But not only, of course, the responsibility to uphold human rights does not rest only on government, but citizens are usually no match to the compulsory processes, the powers of the state in pursuing its agenda, and oftentimes in our experience in the commission, human rights are trampled upon. And so our commission sometimes finds itself at the end of its wits as to how we can respond to all these pleas for assistance, which is, of course, our major mandate, to uphold human rights. And might I also emphasize to our students, but that human rights is also a basic principle in good governance, that if you do not have full respect for human rights, you do not have good governance, you break down the rule of law, your society becomes unstable, and then you have a lot of problems later on. So the pervasiveness of human rights behind all our statutes, and the requirement that our government respect these human rights in the implementation of its programs forces us to address almost all queries. Some of the queries that are forwarded to us at first glance might not seem to be immediately related to human rights, but upon further analysis, you will know that at the bottom of all these are actually fundamental principles in regard to human rights. And so we are forced to do our best to address them. And oftentimes it leads us to reach out to institutions, to civil society, to fellow lawyers to help us fulfill our mandate. We all know that the cases of extrajudicial killings alone have already engaged our lawyers almost full time. And in fact, up to now, we're having a hard time resolving all the cases, the thousands of cases that have been filed before us. But even assuming that we have the capacity to fulfill all this, which we do not have, but even on that assumption, I say that it is still good policy to reach out to fellow lawyers, to legal institutions involved in the teaching of law, to all sectors, because human rights, after all, is a collective endeavor. It is a responsibility of all citizens who have the capacity to help uphold human rights. So before ending, I just want to share this experience in my first meeting with Professor Vistan. I hope Professor Carlo, you will forgive me for saying this, but Professor Vistan was very humble when he started our conversation in saying that the reason why he was appointed as director of OLA was because of his extensive litigation experience. But I believe that there is something more than that, because my initial conversations with Professor Vistan has made me immediately appreciate his commitment, not only to his profession, but his responsibility, his duty to contribute to society as a lawyer. And that was immediately apparent, but he was just too humble to mention it, but I immediately sensed it. And I would like to congratulate Dean Cordero Tan for putting in such a good man, competent person as head of this Office of Legal Aid of the UP College of Law. And I would also tell the UP senior students right now that you're very lucky to not only have a very, very competent lawyer guiding you, but who has a heart for human rights and the rule of law as well. Pasensya ka na. I hope I didn't embarrass you too much, Professor Vistan. But it is I congratulate Dean Cordero as well for making such a good, wise choice. Anyway, things have happened quite quickly since we first reached out to the UP College of Law. And this is a work in progress. Even as we are talking now, my staff is trying to figure out the development of certain protocols that will smoothen out the interaction between our two institutions and ultimately with the public in rendering assistance to them. So I would pray the students to be patient with us as we start with this program, because I'm sure you will be developing, you will be experiencing glitches, as in fact we are now because of this the blackouts and etc. So glitches will happen. Please be patient as we operationalize this program, but rest assured that everybody in my staff is trying his best, her best to smoothen out, to perfect our protocols. As we always say in the CHR, our work is always a work in progress. So in ending, I would like to thank my staff, Raquel here. I cannot mention all of you. Si Attorney Ona, I don't know if she's still here. Attorney Martin, of course, who has been coordinating with the UP College of Law, with Professor Vistan, with Dean Cordero Tan. Congratulations, and I recognize your sometimes heroic, sometimes overnight efforts in putting this event together and in ensuring that this program will run smoothly. So again, thank you very much to everyone. Raquel, I give back the floor to you.
Thank you, Commissioner Cadiz. We all certainly look forward to the launch of the EELS with the fervent hope, given the support of our partner, the UP College of Law, that it provides a practical measure to the ordinary man of the guarantees secured to them under the Constitution. It's a great honor to be part of this program with such laudable purposes. Now, we have a remarkable roster of speakers for you this afternoon who will inspire us to become better human rights workers as we support the EELS. Who better to start off our learning than the chairperson of the Free Legal Assistant Group, or FLAG, who will talk about the challenges and relevance of human rights lawyering. Dean Diokno was also part of the first iteration of a similar mobile lawyering system that was implemented many years ago by a CSO, the Libertas, the Lawyers League for Liberty, for which he served as resource person. May we call in now Dean Jose Manuel Diokno. Dean, good afternoon.
Thank you, Director. Good afternoon to everyone. Commissioner Cadiz, of course, good friend of mine, Dean Deng Cordero Tan, Professor Vistan, and of course to all the students who are here this afternoon. You've asked me to talk about human rights lawyering, what differentiates it from traditional kind of legal aid. And rather than tell you in the abstract, I think I'd rather share with you a story about how human rights lawyers were born in the Philippines and what kind of philosophy many of us adhere to. I have some slides, if I may be allowed to share screen. Yeah. This is really a story about the group I belong to, the Free Legal Assistance Group. But it's also a story that uh, really is shared by all human rights defenders. It began before you were born, most of you, except for probably the panelists and the lawyers here. But it is still very relevant today. And it's really a different kind of legal aid because it is directly and intimately connected to the right to develop. Just to put this in context, we have three basic individual rights. We have, of course, the right to life, then the right to live with dignity, and the right to develop our potential to our full potential. Collectively, we also have three basic rights. As an individual, I have a right to life. Collectively, as the Filipino people, we have a right to survive as a people. Second, in the same way that as an individual, I have a right to dignity. Collectively, we have a right to self-determination, to determine for ourselves without being dictated upon by any other country what kind of direction we want our country to go through. And just as we have a right to develop individually, we also have a right to develop collectively as a people. So let's start the story with the time before martial law. Of course, I know most of you just know about this time because of what you have read or seen, maybe the videos and movies you've watched. But let me just summarize it this way. Before martial law, we had a society that was far from perfect, but at least we had a political system that was outwardly democratic, a constitution and laws that recognized the rights found in the Universal Declaration of Human Rights as legal rights. We had an independent and generally upright judiciary, and a Congress that was making efforts, however they could, to address the social ills that the country was facing. And of course, a press that was regarded at the time as one of the most free in the entire world. But martial law changed all of that. Ferdinand Marcos abolished Congress, censored all the news, controlled all communications media, gave himself the power to legislate and to arrest any person. He outlawed strikes, peaceful public meetings, and even student councils, stripped the judiciary of its independence and integrity, and really transformed lawyers into glorified fixers. Because he had control of the judiciary, because he could remove any judge at any time, he really changed the legal profession. During that time, that was the time when organized, syndicated fixing of cases really emerged. Because when the lawyers realized that the judges had to, pay homage to Malacanang, to Marcos, they had to be close to him and could not make any rulings that he would not like for fear of being removed from office. Then the lawyers, some of the lawyers, not all, but some of them realized that if I wanted to attract the biggest clients, then I needed also to cultivate my relationship with the Marcoses. And they became that kind of glorified fixer. Dito kayo sa amin, akong abogado nyo, pag akong lawyer nyo, siguradong panalo tayo dahil dikit ako kay Marcos. These are just some of the effects of the Marcos regime on our society. Marcos jailed thousands of Filipinos who became known as political prisoners. The document you see to the left of the screen is an example. This is a genuine presidential commitment order, courtesy of the Human Rights Victims Memorial Commission. And you'll notice that five of the persons named in this arrest order, this is essentially an executive arrest order, were priests, members of the and nuns, members of the Catholic Church. The illustration you see here, yung may nakasulat na ASO, PCO, and PDA, refers to the three executive arrest powers that Marcos exercised. Initially, it was early part of martial law, ASO, Arrest, Search, and Seizure Order, followed by PCO, Presidential Commitment Order, and then PDA, Preventive Detention Actions. And even lawyers at the time, some of them from FLAG, were victims of these kinds of executive arrests. The pictures you see to the left part of the screen, you see in the middle picture that is Katani, Lorenzo Tañada, the grandfather of Erin Tañada, one of the founders of FLAG, giving legal advice to political prisoners in Bikutan. That detention facility, I believe, still exists up to today. To the left, you see my dad together with some nuns visiting a detention facility. I think this is also somewhere in Metro Manila. It was also during the Marcos time that his soldiers employed some of the most revolting forms of torture. What you see on the screen are just some of the forms of torture that were used during that time. It ranged from electric shock, water cure, Russian roulette, animal treatment, sexual abuse, and so many other types of torture. And you know, most of the people who were victims of this torture were young people. In fact, from what we have gathered, the Marcos dictatorship probably destroyed some of the best and brightest members of the youth during that period of time. In the name of counterinsurgency, which was the bogeyman of the Marcos dictatorship, in so many ways like it is today, Marcos's soldiers attacked rural communities. They did hamleting, food blockades. Hamleting is isolation of communities, not letting you go in or out without approval of the military. Food blockades, forced evacuations, and even massacres. The picture you see to the left of the screen are pictures of, one is a survivor of the Daet massacre, the others were killed in the Escalante massacre. In the rural setting, the dictatorship was responsible for dispersing peaceful gatherings, conducting what they call saturation drives, which, by the way, still are being done by the police up to today, and demolished a lot of urban poor communities. In short, Mr. Marcos replaced democracy with dictatorship. He changed civilian authority with military rule and supplanted justice from the courts with justice, quote unquote, from the barrels of the guns of his soldiers and police people. And that also had made a major difference in the legal aid. Because before martial law, while the poor and marginalized were also looking for legal aid, most of the time they were simply looking for legal aid because they were accused of common crimes or because they needed lawyers to help them resolve private disputes, issues of child support, husband and wife relations, domestic relations, property disputes, and the like. But during martial law, the poor began seeking legal aid against abuses being committed by the state, which include demolitions, forced resettlements, arrest and prosecution for political crimes like rebellion, massacres, EJKs. At the time, hindi pa namin tinatawag na EJK yan. Ang word namin for EJK was salvaging. Hamleting, food blockades, forced evacuations, disappearances, torture, illegal dismissals of workers, invasions of the lands of indigenous peoples, abuses against farmers and fisherfolk, among others. And not many lawyers were willing to handle these types of cases. Marami sa mga abogado noon, either natakot sila o kaya natakot din sila na baka balikan sila, or they were afraid that it would damage their reputation in the sense that paying clients would shy away from getting them because they would be identified as opponents of the Marcos dictatorship. But there were a few courageous lawyers who agreed to take on these cases. And among them were my dad and Lorenzo Tañada and several others. These were very highly respected statesmen and lawyers. And these two men were the founders and prime movers of FLAG, which was established during the darkest days of martial law, that is around October of 1974. FLAG, as you see in our logo, that's in pre-Hispanic Filipino alphabet or baybayin, referring to FLG. When FLAG was first created, lilima lang ang miyembro niyan. Kapepe, Katani, Alejandro de Chauco, Joker Arroyo, and Luis Mauricio. By 8 years later, 1982, FLAG had grown to more than 150 lawyers, all from different parts of the country. But The legal aid that FLAG was providing was very, very different from the traditional legal aid that lawyers were providing before martial law. I quote from one of my father's papers about this kind of legal aid. He said, by spreading a chilling climate of fear over the nation and by steadily militarizing social institutions, martial law has led lawyers and lay people to question not only the political system of martial rule, but even the social, economic, military, and cultural structures that led to martial law and nurture, sustain, and prolong it. As a consequence, martial law added a new dimension to legal aid. By politicizing lawyers and lay people, it politicalized legal aid. And he went on and he said, to contribute effectively to development, legal aid lawyers will first have to determine, are my clients' problems, legal problems, are they personal problems or social problems? Do they affect only my clients or an entire social sector or community? If the answer to that question is the latter, then legal aid lawyers from FLAG and other organizations would attempt to seek to work with their clients to seek the specific social cause of the legal problem, a particular social structure and social forces that generated that problem, and together try to work out not just legal but also social solutions. And that process of working with the client created an awareness of the social causes of injustice. And that resulting awareness then it emerged from them a determination on the part of lawyer and client alike to change law in society to correct injustice. And that in itself is the beginning of development. But they realize as well that it would not be enough to fight the battle in the courtroom. Lawyers who practice this kind of what later became known as developmental legal aid also needed to educate. They needed to make full use of their educative function. So FLAG began to publish legal primers, as you see in the picture, about our rights, your human rights in Filipino and in English, and other primers on political prisoners, rights of laborers, and so forth. That would help ordinary people understand their situation and what their rights are, and as well, what their rights should be, and why many of the institutions during that time were not recognizing those rights. But educating people, raising awareness is just half of the challenge, because the other half has to be leading them to action. Because if you could have a heightened awareness, but if you don't do anything, that could just lead to apathy. So legal aid lawyers, like those who belong to FLAG, began to encourage people, the people they were serving, to organize, to act collectively, and to invest and use meta-legal tactics in order to challenge those unjust and inhumane policies and practices of the dictatorship. And that is how developmental legal advocacy was born. It was in the fire of the dictatorship. And if there's any one good thing that came out of that Marcos dictatorship, I think it is this concept of DLA, as well as the birth of human rights lawyers and human rights defenders. Just to quote to end this section of my talk, so development requires a different type of legal aid, one that will not supplant traditional legal aid, but supplement it, concentrating on public rather than private issues, intent on changing instead of merely upholding existing law and social structures, particularly the distribution of power within society. So you will notice that unlike traditional legal aid lawyers who were only concerned with handling the case itself in court and winning the courtroom battle, developmental legal aid lawyers were really more concerned with a bigger question, and that is the question of empowerment, the question of raising awareness, getting people to fight for their own rights, not even to rely on lawyers or to be dependent on them, but rather to become self-reliant even when faced with state abuse. This type of legal aid would rest on firm legal ground, the right of the people to development. And it is based on the recognition that just as law can be used by the oppressors to oppress the poor and the marginalized can also use law to liberate themselves. And while the kinds of cases we handled were a lot where the legal assistance we provided was inside the courtroom, the picture in the middle of the screen is my father together with the then coordinator of flag for Davao, Attorney Jess Albacete. The picture on your left is the one standing in the middle with his side view is Attorney Arno Sanidad, a very young Arno Sanidad. The man seated is Randy Echanis, who was just the victim of an EJK very recently. But while the assistance we provided was inside the courtroom, we also went beyond the courtroom and into communities to render developmental legal aid. What you see in the screen is a picture of the very, very first ever paralegal training workshop ever conducted in the Philippines. This was done in Mary Hill Seminar, June 11, 1981. Some of those in the picture went on to become quite well-known and respected human rights lawyers. Some of them in the picture are also from UP Law. But we did not just fight the battle inside the courtroom. We also conducted, as I showed you, paralegal training and a lot of fact-finding missions. The founders of FLAG went up to Kalinga and Bontoc to help fight, to help the indigenous peoples there fight against the Chico River Dam. You have also pictures here to the right of the screen about the massacres and other human rights violations that were investigated by FLAG. And I must pay homage as well to Sister Mariani Di Maranan, the very first head of Task Force Detainees of the Philippines. She really, really gave her life to helping political prisoners, and she deserves a lot of recognition. But earlier, in one of my slides, I mentioned that one difference between traditional legal aid lawyers and developmental legal aid lawyers is also that we recognize that the battle is not just in the courtroom. If we want to help really our clients empower themselves, then they must take the cudgels for their own fight. And that involves them engaging in meta-legal tactics. These are nonviolent group actions that transcend the usual judicial and administrative procedures, yet remain faithful to the basis of law, because they seek the common good and are really meant to supplement the legal tactics that are being done on their behalf. So meta-legal tactics could include online and nowadays online petitions. At the time, they were handwritten or printed petitions, statements of support or condemnation, memes, slogans, mock awards, election expression through art, songs, even cheer dances, noise barrage, sit-ins, basically anything creative that can grab attention, highlight the issue, and capture the imagination of the people. But I must emphasize that unlike traditional legal aid lawyers, upon whom clients were mostly dependent, because everything depended on the outcome of the case in the court, flag lawyers, we see our role as very supportive. Our role is really to assist the client in generating law themselves. The poor and marginalized really have to rely on their own efforts and not on lawyers to forge a better society. And for them to do that, of course, what we did was we would, and we still do this, we encourage our clients to organize themselves, to work together, to network, to find other organizations that also are working on the same cause, even if it's from a different direction. So for example, we would sometimes put together members of the indigenous peoples with urban poor communities. While they would seem to be miles apart, bottom line, when you analyze their situation, you realize that their basic issues are very similar. Of course, this kind of strategy may not succeed all the time, but if it is done, it is very empowering. And it helps to overcome that sense of impotence, which is really the most serious obstacle to development that centuries of oppression have instilled in our poor and marginalized, and replace it with a sense of power that is really capable of releasing the kind of creativity and drive that we all have as human beings. And that in itself is development. Thus, the struggle to develop the forge a better society must involve a struggle over law. And in that struggle, the poor and oppressed do not just have to sit still. They can use the law to liberate themselves, just as the oppressors have used the law to oppress them. Of course, the law may not prove to be a sufficient weapon, but it is still a weapon that is to be contended with, something that we can use. Just to, I'm now in the final section of my short talk, and please let me know if I'm going over time. But just a question, how does DLA work in terms of our relationship with our clients? Well, unlike traditional legal aid lawyers, we really work hand in hand with our clients in terms of helping to educate them about what their rights are. We do a lot of paralegal training. We go to the communities, organizing them and mobilizing. We encourage them. We don't do the organizing itself, but we encourage them to organize. We encourage them to mobilize and to undertake meta-legal tactics that could help in terms of their own bonding with each other and also to raise awareness and support from the general public. That's why in all dealings with our clients, we make it a point that all flag lawyers bear in mind the following. First, that aside from our responsibility to win the case in court, we also have a responsibility to educate our clients, not only on what their rights are, but on what their rights should be. Second, that we must be willing, and we must do this as often as we can, to explore with our clients the causes and solutions to their problems, to engage them in meaningful dialogue in the spirit of stimulating them to think for themselves and to come up with their own solutions to their problems. Third, we make it a point to keep our clients always updated on what is happening in their case and to involve them in the decision-making process without at all breaching our ethical duties as legal advocates. Fourth, we encourage our clients to network, to broaden their networks and alliances, and to be organized so that they can act collectively. And fifth, we really try as much as we can to avoid making our clients dependent upon us and really to strengthen their own self-reliance and creativity. And that brings me to the second to the last question. What knowledge, skills, and techniques must DLA lawyers develop to effectively practice developmental legal aid? Of course, you have to know what is found in our international human rights instruments to which our government has ratified and which we are obliged to comply with, what is found in our national law on human rights. We have to be aware of the national situation and the situation of that particular sector or community we are servicing, and also the laws, which I'm sure you law students have very familiar with, both the laws that are used to oppress the people and the laws that are progressive laws that can be used for the protection of our clients. To do this, and since you're still in law school, I suggest you really undertake every effort to improve your skills in the following: interviewing and counseling clients, documenting human rights violations, conducting mediation and negotiation, of course, in litigation, marshalling the evidence, researching the law, drafting pleadings, conducting direct and cross, and introducing exhibits. Last point before I end. Is DLA still relevant now in the new normal? Well, I think you will notice that during the pandemic, parang lalo pang dumami yung injustisya. Parang lalo pang lumitaw yung doble cara na mukha ng justice sa Pilipinas. Pagka ikaw ay isang nasa laylayan ng ating lipunan, napakadali kang maging biktima ng pang-aabuso. Pero kung ikaw ay isang senador or isang malaking tao, kahit na obvious na may ginawa kang hindi tama, o naglalabag sa ating mga regulations ng IATF o ng municipal or city ordinances ay hindi ka man lang kakasuhan at wala kang pananagutan. So to me, developmental legal aid is very, very important today under what we call the new normal. The economic situation as well, I think, provides the need for legal aid because given the terrible rise in unemployment, given the failure or closure of so many businesses, we are really going to feel the impact, I believe, starting next year of that on the poor and the marginalized. Yung mga mahihirap bago ng COVID ay lalo pang magiging mahirap ang kanilang buhay at madadagdagan pa sila. Kaya I hope that you all consider at least finding ways to get involved in terms of providing legal assistance, as all of you are. And I'd like to thank you and the CHR for this initiative of providing legal assistance through the internet. Yeah, just to end with a quote, something my father said, to allow injustice to prosper without protest when the occasion to protest arises is to compound the hardships and the sufferings of the people. By the way, the picture you see on the screen, that is of Lino Broca and Ben Cervantes. Palagay ko, kilala niyo naman silang mga magigiting na director yan, who were both imprisoned by Marcos for joining a jeepney strike. And while they were able to get bail, they were not released initially because Marcos issued a presidential commitment order against them. But this is one of the few successful cases that Flag handled during martial law. You know, as human rights lawyers, you have to already have the mindset that in a situation of a dictatorship, you're going to lose a lot of cases. But the case of, this case later became known as Broca versus Enrile. Ma'am Heidi Orak was the lawyer for the petitioners in this case, and we got a favorable ruling from the Supreme Court. I'd like again to thank CHR, Cadiz, and all the CHR officials, and of course UP as well for this opportunity to share the story of developmental legal aid. Thank you and good day.
Thank you, Dean Diokno, for your inspiring and sobering stories. I'm sure that our students today will be more driven towards service through developmental legal aid, starting with our EELS, and hopefully adopting it as part of their life's mission as lawyers. Unfortunately, Dean Diokno will not be able to join us in the open forum due to another engagement. So Dean, please do accept our thanks now for speaking to us and rendering your support to the Commission and this program. Thank you, Dean Diokno.
Yes, if there are any questions, you can send them to me, and I'll find a way to get them, maybe through Prof. Vistan, to send my answers to the participants. Thank you.
We will do that. Thank you very much, Dean Diokno. At this point, we also welcome another member of the faculty of the UP College of Law, Professor Tanya Lat. Welcome, Professor Tanya. We proceed now to our next module. Here we will have a quick review of the mandate of the CHR so that we may be able to overcome the threshold question whenever the services of the EELS are called upon. And that question is, does the query involve a human rights issue? Our next speaker is Melchor Cayabyab, who is a training specialist in the Advocacy and Information Campaign Division of the Human Rights Education and Promotion Office of the CHR. With that, I yield the floor. Please welcome Melchor Cayabyab.
Okay, maraming salamat, Atty. Raquel.
Magandang hapon.
Okay, magandang hapon. Oops. Okay, sige lang po. Okay, isang mapagpalang hapon po sa lahat. Naririnig po ako, Atty. Raquel. Isang mapagpalang hapon po sa lahat sa ngalan ng Human Rights Education Promotion Office ng Commission on Human Rights sa pamumuno ng aming director na si Atty. Tom Temprosa. Kami po ay nagpapasalamat sa opisina ni Commissioner Cadiz at sa mga kasamahan natin sa e-learning project sa imbitasyon sa amin na magbigay ng pagtalakay sa usapin ng mandato o gawain ng Commission on Human Rights. So sino ho ba si Commission on Human Rights? Magkakaroon lang ho tayo ng mabilis na pasada at aalamin din ho natin kung alin sa mga usapin nasa ilalim ng jurisdiction ng CHR. So sino ho ba si Commission on Human Rights? Tayo ho ay isang national government agency. Kaya ho sa ating logo ay nandoon ho yung Republic of the Philippines. Mahalagang paglilinaw kasi yung iba akala ho tayo ay isang civil society organization at mas mahirap nga ho yung iba akala funding agency si CHR. As a national government agency, tayo ho ay isang institusyon na hindi ho nakapaloob sa executive, legislative, and judiciary branch of government. Tayo ho ay kahanay ng iba pang mga constitutional commission or offices tulad ng Civil Service Commission, ng Commission on Election, ng Office of Ombudsman. So tayo ho kasi ay isa sa mga ahensya ng gobyerno na nilikha under the 1987 Constitution sa ilalim ng Article 13, Section 17, kung saan create tayo, there is by created an independent office called the Commission on Human Rights. Ito ho ay bilang pagtalima din ho doon sa mismong simulain at ng ating 1987 Constitution, which is naglalahad ho sa Article 2, Section 11, that the state values the dignity of every human person and guarantees for respect for human rights. Malino ho ang itinatadhana na ang Estado ang pangunahing naggagarantiya ng paggalang sa ating mga karapatang pantao. At ito ay isa sa mga minomonitor ho at gawain na sinisiguro ho ng Commission on Human Rights. Tayo ay nalikha bilang response to the grave human rights abuses na naranasan ho ng sambayanang Pilipino sa panahon ng martial law na sa ilalim ng diktadoryang Marcos. Kaya ho, makikita ho natin na marami sa mga usapin ho natin nilikha para tayo hindi na maulit pa yung mga naganap na paglabago sa ating mga karapatan. Tayo ay isang independent national human rights institution. Gaya ho nang nakikita ho natin, hindi ho tayo nakapaloob sa executive, legislative, and judiciary branch ng government. Nang sa gayon ho ay magampanan ho natin ng independyente o malaya yung ating mandato. Tulad ho ng iba pang mga constitutional bodies tulad ng Commission on Audit at iba pa. Ano ho ba yung role ng CHR as an HRI? Tayo ho ay advocate, tataguyod ho na taga ng karapatang pantao, watchdog, nagbabantay, advisor, at educator. Nino, primarily ng pamahalaan. So mahalagang ilinaw ho ito kasi minsan nalilito iba. Ano ba eksakto yung gawain ninyo? Primarily, tayo ho ay advocate, watchdog, advisor, at educator mismo ng pamahalaan. Bagamat kinikilala ho ng CHR na ang karapatang pantao ay obligasyon ng lahat. Gaya nga ho ng paniniwala namin that everyone is entitled to human rights and everyone has duty to respect other people's human rights. Ganun pa man, sa ilalim ho ng ating on the principle that those who will power and its joy, its perks should exercise greater responsibility. Heavier expectation from the states and their officials. So malaki ho mas malaki yung ating sinisingil na pangunahing obligasyon ng pamahalaan sa usapin ng karapatang pantao bilang bahagi ho ng tinatawag nating social contract. Na kung saan tayo bilang mamamayan ay nagtaydo ng isang estado o ng gobyerno at yung mga pinuno nito ay pinag-ubayan natin yung ating mga problema at pangangailangan at kasama rito pati yung ating mga resources at binigyan natin silang authority to ensure na dapat ay gagampanan nito ang kanyang tungkulin. At mismo ito ay nakatitik sa ating 1987 Constitution na kung saan nakapaloob na ho mismo that human rights is a state obligation. The state values the dignity of every human person and guarantees for respect for human rights under Article 2, Section 1. Kaya nga ho, pangunahin ang gobyerno ang mayroong pangunahing obligasyon sa usapin ng karapatang pantao. At bahagi at sakop ng kanyang obligasyon ang irespeto ito. The state must refrain from interfering with or curtailing the enjoyment of human rights to protect individuals and groups against human rights abuses at siya rin ho yung may obligasyon na isakatuparan ito dahil nga nasa kanya yung resources at manpower para gawin ito. So the state obligation to human rights, respect, protect, and repeal. Kaya nga ho sa pamagitan ng tinatawag nating iba't ibang ahensya ng pamahalaan na mayroon ito, na mayroon siyang mga kanya-kanyang specific na karapatan na mandated niyang trabahuhin. Halimbawa, yung right to life, liberty, and property, trabaho ng Philippine National Police, yung right to education, Department of Education, yung usapin ng Social Security, ito po ay obligasyon ng SSS at GSIS. At ang trabaho ni CHR ay siguraduhin na nagagampanan ng mga ahensya ng gobyerno na ito ang kanyang gawain at ang kanyang obligasyon sa mamamayan. So ito rin ho, gaya ng binanggit ni Dean Diokno kanina, ay ito'y bahagi din kasi ng ating obligasyon ng gobyerno bilang nag-ratify o signatory sa iba't ibang mga international human rights treaties and instruments, which is kasama sa minomonitor ni CHR na dapat niyang nagagampanan. Kaya nga ho, dun sa konsepto ng reciprocal relationship, ang duty bearer ay ang gobyerno at ang right holder ay ang mamamayan. So, ang obligasyon ng gobyerno, ipulpil ang kanyang responsibility sa usapin ng karapatang pantao, accountable siya sa mamamayan, at ang kanyang mamamayan naman ang nakiklaim ng kanyang rights. So, ito po. So, the state and its agents, sila yung duty bearers because they hold the authority, resources, and systemic power. At ang rights holders naman ay ang mamamayan. So, ano ho ba yung powers and function ng CHR sa ilalim ng Article 13, Section 18 ng 1987 Constitution? So, una, investigate all forms of human rights violations. Mamaya ho, babalikan ko ito, bibigyan din kasi ito ho yung pinaka-controversial ho na nagagamit ho para magkaroon ng misinformation, disinformation sa trabaho ni CHR. So nagsasagawa din ho tayo ng visitorial powers over jails, persons of detention facilities. Sinisiguro natin na yung ating mga detentions, mga kulungan natin ay at least nasisiguro na walang nagaganap na torture or inhumane na pagpaparusa, at the same time ay papasaho sa pamantayan ng karapatang pantao. Ito ho, yung trabaho ng aming opisina, establish a continuing program of research, education, and information to enhance respect for the primacy of human rights. So, yung mga human rights orientation na sinasagawa ho namin, pakikipag-ugnayan sa iba't ibang civil society organizations, yan pa. Security sector. Sa local government units. Okay. Bahagi din ho ng trabaho ni CHR bilang advocate ay advisor ng pamahalaan ay ang magrekomenda ho ng mga pamamaraan paano mapopromote ho yung human rights kasama yung protection and fulfillment ho nito. Halimbawa, kasama ko sa nirecommend natin sa Congress yung effective measures to promote human rights to provide compensation to victims of violation of human rights or their families. Particularly nung panahon ng biktima ho ng martial law ng diktadoryang Marcos. So ito ho yung Republic Act number 10368, which is na nag-provide ho ng reparation and recognition ng victims of human rights violation during the Marcos regime at yung pagpo-provide ho ng inaasahang pondo para dito. So yan po. Nagmo-monitor din ho tayo, gaya ng binanggit ho natin kanina, yung ating gawain ho, yung compliance ho ng gobyerno sa mga international treaty obligations ito sa human rights ng kanyang mga pinirmahan. At marami-rami ho ito na kanyang mga pinirmahan. Nagre-request din ho tayo ng assistance of any department, bureau offices, agency for performance of its functions. At ito ho yung mahalagang tanong. So, investigate all forms of human rights violations. Kailan nag-iimbestiga si CHR? So, kanina gaya ng binanggit natin, sino ho yung pangunahing may obligasyon sa pagbibigay proteksyon, paggalang at pagtatagoy at pagsasakatuparan ng karapatan ng pantao, pangunahin yung pamahalaan. Kung kaya't may mga 5 circumstansya na kung saan darating si CHR para mag-imbestiga. Una, kapag ang perpetrator ho ng anumang krimen o anumang pang-abuso ay mga taga-gobyerno, so yun po ay darating si CHR para mag-imbestiga. So ang unang sitwasyon, kapag ang perpetrator ay mga taga-gobyerno. Kapag ang perpetrator ay mga pribadong tao, so ito ho ay isang krimen, ito po ay trabaho ng mga law enforcement agency tulad ho ng Philippine National Police, pangunahin. Ikalawa, darating din si CHR regardless kung ang perpetrator ay taga-gobyerno o pribadong tao kapag ang biktima ho ay mga kabilang sa marginalized, disadvantaged or vulnerable sector. So ulitin ko ho kanina, darating si CHR para mag-imbestiga kapag ang perpetrator taga-gobyerno Ikalawa, kapag ang biktima, regardless kung sinong perpetrator, ay kabilang sa marginalized, disadvantaged, at vulnerable sector. So kung makikita ho ninyo, kapag may mga bata na nagagahasa, na abuso, dumating ho si CHR regardless kung sino ho yung perpetrator. Ikatlo, kapag wala, hindi sapat o labag sa batas o mali yung naging pagtugon ho ng pamahalaan. So limbawa, kapag ahente ho ng gobyerno ay walang ginawa, hindi sapat, mali o labag sa batas ang naging aksyon, ito ho ay nagbunga ng pagkakait ng karapatang pantao, ito ho ay isang criminal at human rights violation. So kung halimbawa kayo po ay na-snatchan ho ng inyong gamit sa kalye, pumunta ho kayo sa isang police station at mula doon ho ay wala silang ginawa at walang naging reaksyon, walang naging effort sa inyong pagsusumbong, kayo po ay pwedeng hong magreklamo sa CHR kasi ito ho ay omission ng ating mga karapatang pantao. So ulitin ko huli kanina, kailan ho darating sa CHR para mag-investigate kapag ang perpetrator taga-gobyerno, kapag ang biktima ay mga kabilang sa marginalized, vulnerable, and disadvantaged sector. At ikatlo, kapag walang ginawa yung gobyerno doon sa mga dapat niyang gawin at kanyang tungkulin. Ikaapat, dumarating si CHR para mag-imbestiga regardless din kung sinong perpetrator kapag usapin ho ng paglabag sa international humanitarian law. So usually sinasabi nila dito ho papasok na kasama ho sa iniimbestigahan ho natin maging yung mga armadong grupo, yung rebelding grupo kapag usapin na ho ng paglabag sa IHL. At ikalima, sa mga non-state actors, dumating din ho si CHR kapag usapin ho ng paglabag sa UN Guiding Principles on Business and Human Rights. So yung mga malalaking negosyo na lumalabag ho sa UN Guiding Principles on Business and Human Rights, kasama ho ito sa mga iniimbestigahan ni CHR. So dun sa tanong na, is the CHR already mandated to look at human rights violations by the state forces? Malinaw ho dito ang pahayag ng aming chairperson, Chito Gascon. Sabi ho namin dyan, hindi naman. Kasi ganun pa man, mahalagang ilinaw na primarily ang inimbestigahan namin ay ang Estado kasi the state has an obligation to respect, protect, and fulfill those human rights. So pangunahin na may obligasyon sa usapin ng karapatang pantao ay ang Estado. At ang mandato ng CHR ay i-monitor ang compliance mismo ng Estado o ng gobyerno at siguraduhin na ginagawa nito yung kanyang trabaho. At kapag ang mismong Estado ang lumalabag, kasama ho ito sa kino-call out ng Estado. Ngayon, kapag non-state actors, mahalaga ding ilinaw na ang may principal duty that to respond to that ay mismo rin ang Estado. So yung law enforcement, protection mechanism, prosecution at iba pa. Ganun pa man, sabi ko nga kanina, darating si CHR, kapag usapin ng international humanitarian law, imbestigahan maging non-state actors at kapag ang paglabag ay sa usapin ho ng business and human rights. So ito ho yung opisina ni CHR. So tayo ho ay may mga regional offices. So sa kabuuan, nasa 600 plus lang ho yung mga empleyado ng CHR at nasa 600 to 700 billion pesos lang ho yung million pesos lang ho yung aming pondo. So maliit na rekurso lang. Kung kaya't napakahalaga ng tulong na maibigkakaloob ng iba't ibang sektor at ng mga tulad ninyo na gustong makibahagi ho sa mga proyekto ng CHR sa pagsisiguro na nabibigyan proteksyon yung karapatang pantao ng lahat. So kami ho ay nananawagan sa inyo na hindi lang manindigan para sa ating mga karapatan, kung hindi higit sa lahat ay manindigan para sa karapatan ng iba, lalo na ng mga walang kakayahan ho na ipagtanggol yung kanilang sarili, tulad ng mga vulnerable sector ho, tulad ng marginalized and vulnerable sector. At in-encourage ho namin na hindi tayo maaging neutral. If we are neutral in situation of injustices, we have chosen the side of the oppressor. Sabi nga ho ni Albert Einstein, the world will not be destroyed by those who do evil, but by those who watch them without doing anything. So be forever vigilant. In-encourage po namin ang patuloy ho ninyong pakikipagkooperasyon sa amin, pakikipagtulungan, dahil ang karapatang pantao ay obligasyon ng lahat at malaki ho yung hamon na tayo ho ay tumindig at manindigan, hindi lamang ho para sa ating karapatan, kundi higit sa lahat sa karapatan ng mga taong walang kakayahang ipagtanggol at ipaglaban ito. Mabuhay po tayong lahat at maraming salamat.
Maraming salamat, Melchor, para sa iyong napakalinaw na paliwanag ukol sa mandato ng komisyon. Makakatulong ito ng malaki sa pagpapalawig ng paghahanda ng ating mga mag-aaral para sa kanilang pagtulong sa ating programa. Salamat, Melchor.
Salamat, Atty. Raquel.
Now we proceed to the actual queries that the currently operating ELS has received since its inception in March, so that we may have a foretaste of the queries that we can expect from the EELS. For this, we have as our speaker Attorney Arlene S. Venn, OIC of the Legal Division, Legal Office of the CHR, whose office was instrumental in addressing many of such queries. Attorney Venn?
Yes po, magandang hapon po.
Good afternoon.
Magandang hapon po sa ating lahat. I-share ko lang po yung screen, ma'am, ng presentation ko.
Yes, sir.
Kung paano. Ma'am, medyo ano po yung ano.
Kailangan niyo po ng tulong, Attorney Venn?
Opo, yung sa ano, ma'am, sharing lang po ng
Sige po.
PowerPoint.
Alright. Dali lang ho.
Paki-try ulit, Attorney Venn.
Okay na ho, Attorney Venn. Parang in-enable na.
Ma'am, medyo may ano po. Anyway, I'll
May
just
glitch?
proceed, ma'am, with my...
Okay lang po. Meron kaming backup. Sige ho, we will try to access it.
Sorry, ma'am, for the technical glitch.
No problem.
Medyo ano lang po. So, umpisan ko lang po yung presentation ko on the CHR.
Yes, go ahead, Attorney
E-lawyer
Venn. Habol
services.
kami. Yes, Attorney Venn.
Apo. Let me start my discussion by stating the CHR vision and mission. So, what is the vision of the Commission on Human Rights? Our vision is to have a just and humane Philippine society of persons equal in opportunity, living a life of dignity, and forever vigilant against abuses and oppression. Ano naman po ang mission ng CHR? As conscience of the government and the people, we seek truth in human rights issues and prevent incidents of human rights violations. As beacon of truth, we make people aware of their rights and guide the government and the society towards actions that respects the rights of all, especially those who cannot defend themselves, those who are disadvantaged, marginalized, and vulnerable. So I will now proceed to the meat of my discussion. Ano po yung definition ng virtual lawyering or the so-called e-lawyering? Virtual lawyering or e-lawyering is a form of legal practice that uses web-based tools to interact with clients. So for our purposes, on the expanded e-lawyering services, we include the provision of e-lawyering services also through phone calls. As compared to the traditional lawyering, the traditional lawyering mainly involves legal representation, court appearance, drafting or filing of pleadings. What is the background of the CHR e-lawyering program? The CHR e-lawyering services officially started on March 2020 after the enhanced community quarantine due to the COVID-19 pandemic and when the ECQ was declared. Initially, the CHR offices involved are the legal division under the protection cluster, the CHR National Capital Region Office, and later on, other regional offices were also involved. Due to the influx of requests for legal assistance or counseling, the CHR, through the initiative of the Office of Commissioner Roberto Eugenio Cadiz, together with the Office of Commissioner Gwendolyn Pimentel Gana, decided to expand the scope of the CHR e-lawyering services to include other stakeholders like the UP Law OLA, the CHR promotion, prevention, and policy offices. What are the objectives of the e-lawyering services? First, to expand the reach of the CHR protection services, especially to persons belonging to the marginalized, disadvantaged, or vulnerable sector. So alam naman po natin na ngayong panahon ng pandemya ay restricted ang movement ng mga tao. So the more na very important yung delivery ng e-lawyering services. Second objective is to expedite the delivery of e-lawyering services, which is primarily legal counseling or giving of legal advice. And I would like to note that if there is a request for legal representation, we will endorse the same to the concerned agency or office like PAO or IBP, or to our partner stakeholders like the UP OLA. And lastly, to be able to screen the requests for e-lawyering services, which concerns human rights issues, and exclude those requests which are not within the CHR mandate. And if such is the case, refer them to appropriate agencies or government offices. Now, I will now present to you the process flow which we follow in the provision of e-lawyering services to our clients. The first step in the e-lawyering process flow is the client sends his or her inquiry to the e-lawyering designated emails or through phone call. It should be noted that the CHR has several hotlines, and also it has this specific e-lawyering email address wherein clients can send their requests for assistance. The second stage is that after receiving the client request for assistance, the CHR dispatcher evaluates the client's query or concern and then forwards the same to the duty lawyer, or in the case of the expanded e-lawyering services, to the coordinator or dispatcher. And then the assigned lawyer or volunteer, upon receiving the referred case, will provide the appropriate legal advice using our email address or through text or phone calls. In case the concern or query does not fall within the mandate of the Commission on Human Rights, the assigned lawyer or volunteer may refer the same to other appropriate offices. And finally, when the client received the legal advice, he can send there are instances wherein our clients send follow-up questions, and in such case the original assigned lawyer will attend or answer to the client's query. And after giving the legal advice, we ask the client to give his or her feedback or level of satisfaction on the legal service provided. What are our e-lawyering protocols? So first, the CHR e-lawyering services work 24/7, but then considering the physical and mental limits of our staff, specifically lawyers and special investigators, we usually have a cut-off time, say from 8 a.m. to 8 p.m. But we make it a point that if we were not able to respond to the client's query immediately, we make it a point that within 24 hours or the following morning, we send our response or advice to the requesting client. As I have said earlier, the lawyer who was previously assigned to answer the client's query will also be the same lawyer who will assist the client if the latter has a follow-up question related to his or her previous request for assistance. Under the Anti-Red Tape Act, our lawyers are required to answer or give legal advice within 15 days from receipt of the client's email. However, if the case is considered urgent, we are required to answer the same within 24 hours from receipt of the email request. Any complaint which involves an actual or possible human rights violation or abuse will be referred to the concerned CHR regional office for docketing and investigation. So dito, pag human rights violation, ang perpetrators are yung mga state forces or agents or mga taong gobyerno gaya ng nasabi kanina ni Sir Melchor. At kung human rights abuse, yung distinction dito is usually mga private persons yung mga perpetrators ng mga human rights dun sa human rights abuses. Another important protocol that we follow is that the rule on confidentiality. Facts and information shared to us by our clients will be treated with utmost confidentiality, and we make it a point to inform them that we observe such a rule. And lastly, before sharing the personal or contact details of the client, we ensure that we first obtain the client's consent in compliance with the Data Protection Act. So ano-ano yung mga types or categories ng mga e-lawyering assistance requests? The cases which we handled are diverse, but karamihan dito po yung usually may mga query or questions relating to the implementation ng mga COVID-19 protocols. Meron din dito, karamihan din yung mga kaso ng eviction from rented properties. And then another category of case which we handled ay yung payment of loans. Kasi in many cases, naniningil yung mga creditors sa mga debtors nila despite the moratorium or yung may grace period given to the debtors. Through the e-lawyering services of the CHR, we also provided legal opinions on important issues. Example dito yung proposal to use caning as punishment for ECQ violators. So on that regard, the CHR e-lawyering team drafted a legal opinion and provided a copy to the concerned government offices. Also, mga kaso ng cyber libel, yung mga nagpo-post sa FB, Messenger, Twitter, na mga medyo critical or parang nagki-criticize sa mga actions ng mga government or mga public officials in the implementation of the COVID-19 protocols. Another one is yung marami din tayong mga cases ng mga requests from PDLs, persons deprived of liberty. In those cases, hinihingi nila yung assistance ng Commission on Human Rights regarding their application for parole, commutation of sentence, or pardon. In case naman kung hindi pasok sa mandate ng commission yung ni-refer na kaso or issue, we refer them to the appropriate government office or agency. So lastly, itong slide ko, hindi yung summary ng list of actions taken by the CHR e-lawyering team. So from March 24, 2020 up to September 30, 2020, meron na tayong 148 requests for legal assistance. Itong 98 dito hindi updated, from March to August lang to. So for September we recorded 50 cases. So for a total of 148. And so yun lang po ang coverage ng overview on the e-lawyering services of the CHR. Thank you, Ma'am Raquel.
Attorney Raquel, you're on mute.
Thank you, Attorney Ven.
You're welcome, Ma'am.
So to cap off our orientation, we will now have a talk on how you, our OLA interns, can concretize your role as human rights counselors within the context of the EELS. To give us a better appreciation of the synergies between the EELS and the UP OLA's policies and activities, may I give the floor to your boss, Professor Carlo Vistan. And again, I remind you to please avail of our Q&A feature, and we will attend to your queries after the talk of Professor Vistan. Professor?
Thank you, Attorney Raquel. I hope you can hear me fine.
Yes. Yes, Prof.
Okay, thank you. So, magandang gabi sa inyong lahat. No? Thank you, Commissioner Cadiz, Attorney Raquel, and all our CHR counterparts for this event, no, where we launched this e-lawyering project, and for the experience and training modules that have so far been provided. I think the Dean has Dean Tan, I think has left for her other commitment, but I also would like to thank her for joining us this afternoon and for agreeing to this project. Thank you, Commissioner Cadiz, for the kind words. I may have misled you somehow. I apologize for that. For the very kind words you gave for this earlier this afternoon. But thank you for that. And we hope that I and the Office of Legal Aid live up to whatever you expect from us for this project. So I usually want to talk about something coming from my personal experience. So let me begin this. I think the closing talk no, by reflecting on an experience I had as a law student. So towards the end of my sophomore year as an evening student in the UP College of Law, I joined the Regional Trial Court of Quezon City as a court legal researcher in one of the branches there, a position I held until I resigned during my senior year to prepare for the bar exam. I was eventually designated acting branch clerk of court around my third or fourth year in law school, after our erstwhile branch clerk of court was appointed to a position in the judiciary. As court legal researcher, I was already learning a lot about the law, the legal profession, the practice of litigation, and how people use the law. As acting branch clerk of court, my learning experience shifted to a higher gear and became one pervaded by practical and profound realizations. One of the starkest of these realizations came when I was first given a warrant of arrest to be signed by myself after our presiding judge had signed the same document. The significance and at that time surrealism of that moment did not escape me. Well, for one thing, I had not known before then that the branch clerk had to sign warrants also, warrants of arrest. No? I was therefore caught off guard by the situation with this particular thought running through my mind. After I signed this piece of pink paper, no, this warrant of arrest, this person whom I did not know or I do not know will probably be arrested, detained, and who knows how else this warrant that I will be signing will affect his life. It was then that I realized, and this was before I became an OLA intern like many of you here, I realized that placed in that position or situation, my signature on that warrant of arrest, my action on that document mattered to that person who could be arrested, and it would also matter to his or her family and loved ones. For some reasons, my thoughts and emotions of that moment are still with me all these years. That particular moment of being given a warrant of arrest to sign as a student, no, not yet even a lawyer, and this duty of being the branch clerk of court is actually one entrusted to lawyers or members of the bar already. That moment was also one when I felt the full weight of this thing we call being a lawyer, and which you as law students are striving or working hard to attain. I shared this experience this evening or this late afternoon because I believe that in the life of a young or would-be lawyer, such a profound experience can significantly shape one's own experience and life in the law. To learn and experience how the law works or doesn't work in a setting where one's decisions and actions affect the lives, property, or well-being of others changes one's mental, emotional, and perhaps even spiritual state when the experience is appreciated in the right way. In equal measure, allowing students such an experience contributes to community building as it marks the infusion of much needed new blood to the legal profession tasked to make the law work for society. We have been fortunate that for close to 5 decades now, the UP College of Law has allowed its senior students the opportunity to have a similar but equally profound experience. Through the college's law internship program, interns are given the opportunity to already be law practitioners while still students, and in a way that matters to other people and to society at large. Because of this, if there is an award for the grandest manner of teaching law to future great lawyers, I would nominate the practical experience you get from our clinical legal education program for the top prize. So when the CHR, the Commission on Human Rights, through Commissioner Cadiz and his staff, approached the UP Office of Legal Aid to propose a collaboration on this e-lawyering project that was presented to you this afternoon, and that will be further elaborated in the coming training sessions. The decision to join forces with the CHR was easy to make. In a nutshell, the e-lawyering project aims to remotely provide quick reaction type legal aid in live situations involving possible human rights violations. The natural synergy of the project's features with OLA's mission and capacity is evident. OLA's legal aid policy of providing immediate, competent, and dynamic legal aid resonates in the project goals and design. More importantly, and this I address to the majority of our audience, or our law interns, I believe that you are equipped with the basic skills and knowledge needed to help in this effort. Having said that, though, there's still room for learning, particularly for our interns to hone their knowledge and skills to cater to the needs of those who would call upon the CHR for legal aid. This project will be our interns' opportunity to actively learn about human rights and human rights lawyering, a facet of the law practice that many of our students will likely see only during their school days, law school days, no? Much like the indigent lawyering practice we do in OLA. In this afternoon's program, my part is supposed to be about the role of interns, no, in this e-lawyering effort. I think that role is not difficult to realize, as many of our interns have been doing their internship for about a month now. And the presentations this afternoon have provided our interns with a very good idea of their role in this project. In simple terms, our interns, no? The majority of you listening to this webinar, together with our CHR counterparts and our counterparts from other volunteer organizations, will be at the virtual front line of this laudable human rights legal aid effort. For our interns, this is not something to be afraid of or be nervous about. I actually stated your role in this effort with confidence that with the guidance of mentors from both the CHR, our College of Law, and other partner organizations, you will be up to that task. On a more practical level, I also do not anticipate your OLA internship schedules and routines to be altered much by this e-lawyering project. In closing, let me therefore express my gratitude to the Commission on Human Rights and the UP College of Law, because their agreement to this groundbreaking collaboration gives OLA and the college's clinical legal education program in general a unique and valuable learning experience that it can share to its students. With all that I have said so far, there's much to be optimistic about how this collaboration between the CHR and the UP College of Law could mutually reinforce the efforts of both institutions and their respective stakeholders to achieve their respective goals. To all our speakers, thank you for all the valuable lessons and insights and information you shared to our interns this afternoon. I believe that the different modules presented today engenders much enthusiasm for the learning still to be had in the coming sessions. Indeed, through this e-lawyering project with the CHR, we look forward to learning new things with our interns and collaborators. The adage, life is the best teacher, is much valued in the UP Office of Legal Aid. So to be presented with a fresh perspective of life through human rights lawyering is very much appreciated. Muli, maraming salamat po, no? And magandang gabi.
Thank you very much, Professor Vistan. Thank you. Can you hear me? Yes, all right.
Thank you po. Thank you. Salamat. din po.
Salamat, salamat. It seems we still have no questions from our students. So in any case, we encourage them to please go over the presentations that were made this afternoon, especially the protocols that were introduced by Jonas. And please do forward all of your questions, and the project team will endeavor to answer them. And we will definitely have another venue to discuss the protocols in detail before we launch the program. So while we do not have any live questions today, please do email us your questions anytime. All right, then we close as we have no more activities left. The EELS is an innovative program that the CHR envisions will bring its services accessible to the regular citizen, the man on the street. I remember when I was an intern myself in online, my classmates and I would be excited comparing notes about the queries and cases we would get to handle. You, our dear law interns, are in a far more unique position to make a far more expansive contribution during these unprecedented times in our country. Remember that this will be a nationwide service to every and all Filipino who wants to know if his endo contract was wrongfully terminated, if the policeman accosting him on the street as he peddles his wares can arrest him, if the wife who is beaten by her husband every day has any effective remedy to escape her hell. Not only does the COVID plague the physical and mental state of the people, it also underscores the great divide between the liberties and freedoms of the rich and the poor, as Dean Diokno has imparted. You will be in a position to provide much needed assistance to one of the last ramparts of our democracy and equality today, the Commission on Human Rights, through this program. We are thankful for that, and again, extend our appreciation to the UP College of Law and the Office of Legal Aid. And with their support and our other partners, including GoJust, we are certain we can do good by the vision for the EELS. So thank you very much. But before I let everyone go, can we request the members of the panel who are still present to pose for a group photo to commemorate this activity? We were hoping to have a group photo including all of the students, but that might be very tedious because we have more than 100 plus students online. So may we just request the panelists to go on board so that we can have a photo op for posterity. And again, while we do that, we request for the last time our OLA interns to kindly type in their names in the chat box.
Attorney Raquel, I'm sure that if they have questions, I will let you know.
Yes,
Baka nahihiya lang sila. And anyway, we have our own platform naman for airing out queries and concerns.
Yes, Professor. And our Attorney Martin Esguerra will be happy to coordinate with you on that for the questions that may come from the students. Thank you. So shall we do a photo op? Who's taking the photo? Jonas?
Yuki.
Yuki.
Hi, hello.
Yes, go ahead.
Okay, sige po. Hi, sorry. Tanggal yung mute.
Right. While we're doing this, let me likewise thank the members of the project team who helped in this activity. Of course, we are headed by Commissioner Roberto Cadiz. The rest of our project team, our members are Attorney Ona, Attorney Martin Esguerra, Jonas Turingan, Ana Abastillas, Francis Yu, Mediatrix Resella, and our latest team members, Gaya de Mesa and Sarah Malyari. Okay na tayo, Yuki? Ready for the photo op?
Okay.
All right.
Count to 3. 1, 2, 3. Okay, wait lang po.
Okay na? I think we're done. Again, thank you very much, everyone. Good night and enjoy the rest of your weekend. Thank you.
Thank you, Attorney Rex.
Thank you. Oh, now I'm seeing the students. Now I'm seeing them.
Mukhang na-promote
Thank you,
na.
Prof.
Oh, okay.
Na-promote na. Thanks,
Ah,
Prof.
okay.
Carlo. Thank you.
Thank you, Prof.
Attorney
Carlo. Yes.
Opo, I think hindi capture lahat ng students.
Hindi na-capture?
Sayang.
Yes,
Oo,
yung mga
sayang.
yun po. Kasi parang hindi sila agad na-promote.
Mm-mm.
So wala silang
That's fine.
camera.
Whatever we have now. Sige. So you can continue to take photos, Yuki.
Si Commissioner Gwen was not able to join us anymore, no? Tama ba?
Hindi prof eh.
Okay.
But her
Hindi,
office is also a champion of this program. Her office and
Okay.
Commissioner Cadiz's offices are in the
I
undertaking
thank her
the
na lang. I think we're still being recorded. No? Thank you na lang to Commissioner Gwen. I hope I see you around in our neighborhood.
Yeah.
We live in the same area.
Unfortunately, Com Gwen I think she had to attend a seminar at the last minute, so she begged off from joining us today. But I'm sure in the next events, she will be able to join us.
So I look forward, Commissioner, to yung parang operational meeting, operationalization meeting natin next week, no?
Yes, in fact,
I'll just coordinate with Martin.
Yes, we will do that. So, Yuki, are you still taking photos o tapos ka na?
I'm still capturing as much as I can po. Kasi may ibang nagpa-pop out na mga names, tapos bigla pong nawawala yung iba. So, nag-screenshot lang po ako continuously.
Okay, just continue to screenshot. Yes, Professor Vistan, we're going to do that. I'm urging my staff to finish writing already the operationalization process and also the templates, after which we will send to you, and then we're going to meet to tweak and make it a more perfect system.
Thank you, Commissioner.
Yuki, advise us kung tapos ka na, ha?
Offer.
Yes po, I think I'm done na po. Parang,
All right.
ang natitira na lang po dalawang, parang I think 100 na lang po. So, na-capture naman po.
Okay.
What?
That's good.
100,
Parang
no?
100 po yung,
Nakunan mo.
yes, na
Wow.
parang attendance sa akin.
Ang galing ni Yuki. All right. Thank you very
Alright, very good.
much. Thank
So,
you.
Attorney Raquel, just
thank
to
you
end
po.
on an organizational matter, let's have an evaluation. Siguro Monday na, no? Kasi
Alright.
si Attorney Ona is no longer with us. Right, Jonas? Yes. She's not with us. So, let's do a meeting on Monday so that we can already also furnish the team of Attorney Vistan
Okay.
with all the protocols, and then we can meet. The two teams can meet together. Maraming salamat,
Okay.
Professor Carlo. Thank you.
Sure.
Is
Sige po.
Tanya Lat still there? Wala na.
Parang wala na.
Okay, hindi ko
Wala
nabati
na po.
si Tanya kanina. Anyway, sige, bye-bye. Salamat sa lahat.
Thank you.
Sige po.
Thank you.
Happy weekend.
Congratulations. I think that was enough.